Hello, everyone. We're on Chapter 8, and this is the right to counsel. So we're going to talk about a little bit of history about attorneys, when one can be provided an attorney, and when one has to get their own attorney. So we'll talk about a little history, and then we'll go into what the rules are for today. So historically, defendants had always had a right to counsel. And our Constitution, it says in the Constitution that you have a right to an attorney. Originally, our founding fathers, when they established the Constitution, they put in the Constitution that you had a right to an attorney, meaning you had a right to bring an attorney to represent you if you so chose. But if you can't afford an attorney at the beginning when our country was young and new, then you weren't in, the government was never entitled or required to provide you with a lawyer. So their idea was not that the government had any responsibility to provide you with an attorney. Their idea was that you had a right to bring one with you. Under King George, you didn't have a right to representation. If you were accused of a crime, the government would put a case in front of the king or the king's governor, and eventually the king's court, and it was the king's whoever the worked for the government would present the evidence, and you could defend yourself if you so chose. You could make a statement, but you were never allowed to bring in someone to represent you as a right. So they put it in the Constitution that you have a right to have someone present with you. All right, so Powell versus Alabama is really one of the first cases where the court starts to make a turn and realize the impact of when an individual is not given adequate representation. Powell versus Alabama is a case with 9 young black men who were accused of raping 2 white girls. These 9 young boys were arrested and convicted within just a couple of weeks from the time the girls claimed that they were raped to the time that these boys were sentenced prisoners was just a very short period of time. The minors were not well educated. They were tried without the assistance of counsel, and it's basically they were railroaded through the process. And so that case went up on appeal, and the court found that the failure to have the assistance of counsel is fundamentally unfair. But in Powell versus Alabama, the original ruling was, and they based this on the 14th Amendment, and they said, look, in cases where it's a capital case, meaning the person could be put to death, and these boys were going to be put to death, and you're unable to afford a lawyer, and then this is very interesting. You can tell the time period that we're in, because you had to show that the person was ignorant, feeble-minded, or illiterate. And then if you could show that the person had mental challenges, like feeble-minded, or uneducated or illiterate, then you could appoint an attorney. But it's not the same as it is today. Like, for instance, back then you would have gotten a lawyer a week before trial or 4 days before trial. Now, granted, the level of sophistication and evidence, physical evidence, for instance, is nowhere near what it is today. So, 1932, they barely knew anything about fingerprints. They knew nothing about DNA. And law enforcement was not trained today like they are in forensics. So, very different world. But you were given a lawyer, but by today's standards, it was not very effective. All right, so about 25 years, the law stays about the same until you get Gideon versus Wainwright. And in Gideon, he is charged with breaking into a pool hall, I believe, and he gets 5 years in prison. And it was a felony case. And so his argument was, I should have been appointed a lawyer because I was going to prison. And so what makes Gideon versus Wainwright so important is that it's the first time that the court, again, it reversed itself and said that anytime somebody's charged with a felony, that they are entitled to an attorney. And again, back in the 60s, you're given a lawyer, not early in the process, but later in the process. And you did have a better opportunity to be represented at trial, but not as well as you are today. And the other thing to think about is this is a huge shift because it placed, for the first time, it placed the burden on government to assign a lawyer in all felony cases. So you went from, for instance, Fresno County has a budget of multi-millions of dollars to run. I think when I was in the office, the DA's office ran at about 25 to, I think between 25 and $35 million a year as a budget. And that's paying for the lawyers, for the investigators, for the staff, and then all the overhead. And the public defender's office, while it didn't receive as much money, but it's also in the millions and millions of dollars in order to function as a public defender's office for Fresno County. And in Fresno County, you have several levels. You have the public defender's office, you have Chumo and Associates, which is the next level. So if the person cannot be represented by the public defender's office, then they're sent to Chumo. Chumo has that organization has a flat fee contract with the government. They get millions of dollars every year, and they take on all cases that come through the criminal justice system. And then if those two agencies are not able because of a conflict to take a defendant, it goes to a third level. And then there's a fourth level, and then there's a wheel. There's a wheel of about, at one point, I know it was at least 10 attorneys, and they simply received a flat fee every year, and they would receive cases as they would come up through the year that needed an attorney. So there is a lot of money now that goes out to pay for defense work. And it all starts with Gideon versus Wainwright. So it'll put a substantial financial burden on counties and states. But the court said that a person, if they're going to lose their liberties, was entitled to an attorney. So that's in 1963. And now today, we go from 1963 all the way today. So now the rule is any critical stage. And this is for all felonies and for all misdemeanors. Infractions, the law says that you are not entitled to public assistance if you are charged with an infraction. So the right to an attorney only applies, this is important, the right to an attorney only applies to felonies and to misdemeanors. It does not apply to infractions. Any critical stage means that it's any time, such as arraignment, bail, motions, pretty much any time that defendant's going to go before a judge, their attorney better be there. There are exceptions. For instance, if an attorney can't be present, they may call the court and say, Judge, I've been ordered to stay here in Tulare County, and I know I have a hearing today in Fresno County, and here's my client's name. I'm not allowed, I'm just not going to be able to make it today. I've talked to my client over the phone, or I'm asking the court permission to continue this case one day. So the judge will go on the record with the defendant in the room. The court will appoint a lawyer for the defendant just for this one hearing, and go on the record, put on the record what the defense attorney said on the phone, and then trail the case for one day. So there are some exceptions, but even then, there's an attorney present, at least physically present. So anytime there's any critical stage, so definitely at any kind of trial or hearing, preliminary hearing, motions, sentencings, or appeals, your attorney has to be present. So what happens when you represent yourself? You have a right to re-represent yourself. It's called in California, we call it a Feretta motion. So the rules are this, that the defendant has to be mentally competent, And what the court's going to do is the court's going to put them on the record and say, I understand you want to represent yourself. The defendant's going to say yes. And then the court's going to give them an admonishment. They're going to say, are you doing this free and voluntarily? And they have to answer yes or no. And then, are you doing this knowing what the challenges are? Which is really important because if you're in custody, you have some substantial challenges. Number one is you cannot get legal advice from the court. Number two, your access to a law library is regulated by the jail, not by the judge. So if the jail only gives you an hour a day in the law library, that's all you get. Whereas if you have a lawyer, they have the freedom to do as much research as they, as they want, and they have no restrictions. If you want to hire an investigator, you have to pay for your own investigator, and you have to meet with your investigator if you're in jail only during visiting hours. So again, you're limited in your contact with your investigator. You're limited in your ability to have access to a law library, and you're not going to be given advice by the judge or by the prosecutor. And so the court's going to admonish you of that. They're going to make sure you understand those rules. And then if the court finds that you're able to function and you understand the rules, they'll allow you to represent yourself. I will tell you, most defendants they struggle with it. They don't understand the rules of evidence. There's a lot of rules of evidence. There's a lot of intricate rules that you have to follow. And that if you don't, for instance, evidence can come in unless you object to it. And if you don't know you have a right to object, then the prosecutor is going to they're going to provide the evidence. It's your responsibility to know when you are allowed to object. It is not the role of the prosecutor to advise you of the law. So if they want to put in evidence, and for instance, if they want to put in a recording, there's by law you have to have a transcript. But you only have to have a transcript if it's demanded by the defense attorney, and the defense attorney can object to a recording being presented to the jury without a transcript. They can object, and the court would have to respect that objection and say, counsel, you have to have a transcript in order to play this recording. But if you don't know that rule, and the prosecutor simply walks in with the tape and plugs it in and starts to let the jury listen to it, then that's on you. You just miss out. So those are some of the challenges. All right, so that's Ferretta. These are just, and this is a list of the difficulties. The court can't give you, the defendant can't give him legal advice. And oftentimes I've seen this over and over again where the defendant will start to ask the court for legal advice. They want to, they don't understand the rules of evidence, so they want the judge to explain it to them. And the judge will say, that's not my responsibility. It's your responsibility to know. Basically, you're being treated as a lawyer. You're being treated as you understand the law with the same standards that the judge would treat any other attorney in the room, which is a very high standard. So in other words, you got to know the rules. Okay, so the next challenge is ineffective assistance of counsel. So what happens when your attorney's not doing their job? And you have, there's certain challenges. Number one, if you are hired by somebody, if you're the person paying for the lawyer, and you have what you believe to be an attorney not doing their job, then you have the same remedy that anybody else does in hiring someone for help. So if you hire someone to repair your roof and they don't do a good job, you can fire that individual. So if you hire an attorney, you have the right to fire them. You have to be careful though, because timing is everything. And if you wait too long before you decide to fire your attorney, the court may not allow you to fire your attorney. They may order that the attorney complete the procedures because of where you're at. In other words, they're not. If you hire a new attorney, you have to start over. So if you're in the middle of trial, and you decide at the last minute you want a new attorney, the court's probably going to deny your motion. So you have to be very careful when you choose to fire your attorney. So we're going to go on to a new lecture series because I'm running out of time, and I'll see you in just a few minutes.